You're watching the legal breakdown. So we are joined today by Mario Nicolais. Mario is one of the attorneys representing the plaintiffs who brought the lawsuit in Colorado disqualifying Donald Trump from the ballot under Section 3 of the 14th Amendment. Mario, first off, thank you for taking the time. You are, again, arguing this case will be argued tomorrow, so we appreciate your time.
I'm glad to do it, and thank you for having me.
Now, let's start with this. What do you expect the Trump team's principal argument in this case will be, and will that inform how your team is going to argue this case?
Sure. Well, so I think there are a couple interesting notes here. Most of this case, they've kind of taken a kitchen sink approach and thrown everything at it. Um, even when they petitioned for cert, they petitioned like one question that encompassed everything. That basically said, did the Colorado Supreme Court get it wrong in general? Which is a really weird and strange way to couch a question to the Supreme Court. But it's because there are so many other questions. It wasn't until we got their brief that we understood what they were really trying to go after. In this case, they're trying to claim that the president is exempt from Section 3 because he's not an officer of the United States.
Okay, well, I guess that raises the question, how do you approach that question? Is the president an officer of the United States?
Well, I mean, I think there are so many ways to approach this, and I think first of all, just a common sense. Of course he is. Of course he is. But even more than that, because obviously that's not a legal argument. When you go through the go through the Constitution, it refers to the office of the president more than 20 different times. And furthermore, you've got people from the 1790s when the Constitution itself was drafted, all the way to the 1860s when the 14th Amendment was drafted, who always thought of the president as an officer of the United States. I'll give you a great example. Federalist 69, written by Alexander Hamilton. I think we can all agree, an expert on the US Constitution. Um, he wrote in Federalist 69, the president is an officer elected by the people. You move forward, you've got Chief Justice Marshall, who referred to the president as an officer. You go into the 1860s, and not only were all these presidents referring to themselves as the chief executive officer, but you also have the folks who were talking about it at the time of, yes, this is an officer of the United States. And stepping back from that, you can't look at the history of what was happening at the time of the 14th Amendment's ratification without realizing that he's an officer and that the president is included here. So, for example, no one would think that Jefferson Davis was going to be qualified to be president of the United States. So obviously it has to apply to him as well.
Okay, Mario, I want to echo what Brian said. Thank you for being here on the day before the big argument, and thank you for the work you're undertaking to represent these plaintiffs and, try to protect our democracy against insurrectionists, which at its core, I think is what we're discussing and what the Supreme Court is going to be required to decide. Let me ask you about this. Do you think the issue of consistency among the 50 states will be argued much tomorrow? Because as we know, states get to run their own elections, including elections for federal office. And you have 50 different states that have passed different election laws, promulgated different rules and regulations. So whereas in Colorado, there was a trial on the merits, worked its way up through the Colorado Supreme Court. If we look up in Maine, you have laws and procedures that say the Secretary of State, Secretary Bellows, holds a hearing and makes a decision about qualifications, and then that can move into the courts and can be challenged, which I think is where things stand up in Maine. Do you think there will be a discussion during tomorrow's oral argument that, we've got 50 states with 50 different procedures, and we have a concern about whether this is going to be consistently applied throughout the states? And if so, how do you tackle that issue?
Sure. I think there are a couple of different ways to tackle it. But first, to answer your question, we expect that it's likely to be asked because if you rule in our favor, what does that mean? The court's going to want to know that. So we do think that that's pretty likely to come up, at least some piece of that in the line of questioning. obviously we brought this under Colorado law, and as you said, each state creates its own laws. And in fact, the Constitution is created that way to allow states to do that. It's simply part and parcel of being a federalist system. And it's federalism at work. So different states have different rules about ballot access and how you access it or not. That said, I think, Colorado was the first state to actually go through the merits. Not only did we go through the merits, but it wasn't some sort of cursory review. Donald Trump got not only all the process that he was due, but I think he got more process than he really thought he was going to get. We asked him to testify. We asked to do a deposition of him, a trial preservation deposition in lieu of actual testimony, and he refused. In fact, not only did he refuse, but he fought it. So instead, we did a 5-day trial with witnesses from both sides. We presented hundreds of pieces of evidence. A lot of it was entered into court. The judge reviewed all of that. There was cross-examination. And Trump's side didn't use even all their time. So we did get through this whole process. We have argued the Supreme Court, owes deference to the fact finding in this case, and so could only overturn it with a clear and erroneous standard. But we acknowledge that it's also a mixed question of fact and law. And so if the Supreme Court does choose to go ahead and take a look at this de novo and review the facts themselves, we're very confident in that. And I'd like to point out, Donald Trump himself has also said that this record is good enough for him to proceed, and that he wants the court to rule on this record. So it's not just us. So I think if the court does that, the evidence is overwhelming. And the evidence is overwhelming that Donald Trump engaged in insurrection, and so therefore would be barred by Section 3.
So let me ask you another question, and if anything qualifies as a fun question, maybe this one does. I'm going to try to suppress the snark in my voice. Do you think Supreme Court Justice Neil Gorsuch will agree with Judge Neil Gorsuch when he had a chance to rule on a related issue about a decade ago? And if you can explain what that earlier ruling was from Judge Gorsuch, and do you think he will remain consistent now that he gets to look at this issue 10 years later?
Yeah, so what you're referring to is then Judge Gorsuch, when he was sitting on the Court of Appeals, wrote an opinion that basically said that a presidential candidate who was trying to get on the ballot and was not a natural-born citizen could be denied the right to ballot access because he didn't meet the constitutional qualifications. And furthermore, he went on to say states have a right in protecting their ballot access and protecting it from kind of fraudulent candidates or candidates who are not eligible, and limiting that. And that actually helped to enfranchise voters by giving them that choice. And so obviously that's been stated. We reference it in our brief. I think the Colorado Secretary of State, cited the same case 3 separate times in their one brief, because I think it's important. And obviously, we know that Gorsuch feels that way. I would throw out there, though, that Justice Gorsuch is one of the originalists, and he's one of the textualists. He's going to look at this clause and say, well, this seems to me exactly what it means. And then when you throw the history that we've put out there and what other people thought about it, I think he's one of the people and one of the justices who will take a long, hard look at this and come away and say, okay, well, this is what the rule of law dictates.
Yeah, it'll be difficult to square claiming that you are an originalist or a textualist and then seeing the plain text of Section 3 of the 14th Amendment and not finding that Donald Trump isn't eligible to run for re-election again. Mario, do you believe that you need a conviction for the 14th Amendment to apply?
No, absolutely not. And no one has ever thought that has been true. In fact, it's anything but that. The framers of the 14th Amendment, when they introduced the 14th Amendment, actually talked about that this was actually almost a leniency, because in most countries, when you engage in a civil war and insurrection, they strip away your property or your rights, or they throw you in jail. They were doing none of that. All they were doing is saying, we're denying you the privilege of running for office. And then, even then, it was only the folks who had taken a previous oath. And so this is such a limited amount that you clearly don't need that. Furthermore, there are other issues. It's a different standard of proof. There's not a beyond a reasonable doubt like there is in a criminal law. So I think that's important to notice. And then there's just the history of the 14th Amendment and how it applied. After the 14th Amendment was ratified, hundreds, thousands of Confederates were immediately disqualified from office, and they knew that. And the reason you know that is because they sent letters to Congress asking them to remove that disqualification, which is the second part and last part of the 14th Amendment, Section 3, which says that Congress can remove the disqualification by a 2/3 vote. So you had all of these folks who understood they were disqualified as of the day that they had engaged in the insurrection, and so therefore were not eligible to hold office again, asking Congress to do that. The very fact that you have so many people who understood it at the time should prove beyond any doubt that no one in this country thought you needed to have a conviction prior to proceeding with Section 3.
So Brian, can I ask a follow-up to your question? I agree. There is no requirement. There's no real authority for the proposition that you have to be criminally convicted of insurrection in order to be disqualified. But I'm interested in how you respond to an argument that perhaps will be made. And that is in Section 5 of the 14th Amendment, it says that Congress shall have the authority to adopt appropriate legislation to enforce other parts of the 14th Amendment. So if Trump's lawyers argue that, well, Congress has done that. They passed an insurrection statute, 18 U.S.C., I think 2383, I believe back in 1948. They said if you engage in insurrection after having taken an oath to support the Constitution, part of the punishment that the judge can impose is you're disqualified from holding office again. So what would be the rebuttal or the response to an argument that says, listen, they followed Section 5, they implemented Section 3 by putting this federal criminal statute on the books. Therefore, you really do need a conviction.
Well, I mean, I think first of all, you have to go back that originally the Insurrection Act, the criminal code was actually predated the 14th Amendment, so it doesn't move through that. But I think also what you have to look at is when we're talking about congressional preemption in Section 3 or self-execution or not, you actually have to look at whether Section 5 has been implemented for this full purpose and preempted states' rights. And that's one of the big arguments we've made is really we're looking at states' rights here and the power that the Constitution gives to states to do this. And nothing in what they did later in that act, Glenn, remove the power of states' rights to say, we're going to run elections the way we want and the way we choose. If Congress had wanted to do that, they needed to go ahead and say, we are preempting that power, and we're exercising our right under Section 5, and we're removing it from the states. They didn't do that.
Yeah, I'm with you, Mario. And let me just bring up something that feels to me like a little bit of an incongruity with the argument that I was just kind of asking you about that you have shot down, and I appreciate that. It seems to me that there's a disconnect between the argument that, well, Congress passed a federal law prohibiting insurrection and providing that the punishment authorized to be imposed by the judge includes a ban from office. But the Section 3 of the 14th Amendment says Congress can remove the disability by a 2/3 vote. Well, that feels like a separation of powers problem. If a judge imposes a sentence, Congress ordinarily can't alter that sentence or remove the sentence that's been imposed. I feel like that's another little atmospheric point that shoots down the notion that there has to be a criminal conviction. And again, I agree with you that there really is no support that there needs to be a criminal conviction.
Yeah, I think that's right. And again, I mean, I just go back to the fact that Section 3 was never meant or intended to be a criminal punishment for anyone. What it was meant to do was protect our country and our Constitution from oath-breaking insurrectionists. We did not want people who we knew we could not trust the leadership of our country taking power ever again. It's not a criminal statute. It's a shield for the U.S. Constitution.
Now, Mario, multiple courts have found that Trump did engage in insurrection. Obviously, the trial court in Colorado, the Colorado Supreme Court, Judge Wallace in California, and then certain indictments were predicated on the idea as well that he engaged in insurrection. That's why the indictment was voted out in Georgia, for example. Is that enough of a finding to satisfy this question of whether he engaged in insurrection as far as the Supreme Court is concerned?
Yeah, and I think one of the other things that you have to take in here is it's not only just what we saw, on January 6th, but people have been laying this groundwork for 3 years since then. So while the decision we had is not reliant on the January 6th findings, what we were able to do is we were able to build a case based on that and go and get folks that we knew would be able to prove the evidence here. So, for instance, Danny Hodges, who was a Metropolitan police officer at the time, had testified before January 6th, and we got him to come and testify in our hearing. So we knew what he was going to say, and we knew what he would tell and what evidence he could give, and we put him on the stand, and he actually testified there. So we were able to use a lot of what has been done so far to build this case, and what would have maybe taken hours or days, we could distill down into a shorter time period to make sure that we fit it within a 5-day trial. And that's a lot of what happened here. Maybe I'm not answering your question, but feel free to prod at me until I do.
What is the Supreme Court going to need as its standard to determine whether Trump engaged in insurrection? Does it take findings from previous courts? Is it going to take information, like you said, from the January 6th committee? Do they have to find whether he engaged in insurrection anew from evidence, irrespective of what they've heard from lower courts? How do they determine whether that standard was met?
Okay, thank you for clarifying. So a couple of things. I think that the first order of business for the U.S. Supreme Court is going to make they're going to have to make legal rule on legal issues. So what does it mean to engage in insurrection? What does insurrection itself mean? They're going to argue. They're going to answer those legal questions, and they're going to answer it for the whole country based on that. Then what they might do is they might look at the record that we have here and the findings and the evidence introduced, and they might say, okay, well, we've defined insurrection. We've said what it means to engage in insurrection. We've answered those legal questions on kind of just the theoretical level. Now let's apply it here with the facts that we have before us. They will stick to the facts that are in the record. And I don't think they need to go anywhere else. We have both the lower court and the Colorado Supreme Court said it was overwhelming, the evidence that we presented that he had engaged in insurrection. And furthermore, not only overwhelming, but almost unrebutted. They just simply put on nothing that really rebutted that. Even when they tried to rebut something like the National Guard, they had Kash Patel on testifying on it. He was so not credible. He was found not credible by the trial court because of the way that he engaged in it. Plus, we had an expert witness who came on who testified that if what he was saying was true, there would be documentation. And then we had Tim Hafey, who was the lead investigator for the January 6th committee, who testified that they asked the Department of Defense for those documents, and the Department of Defense returned everything that they had, and it didn't include any such documents. So, I mean, I think when you look at our record, that's all they're going to need. And really, Supreme Court shouldn't be going outside of the record presented to it. But in our case, we don't think they need to.
Glenn, you want to jump in? Do you have any other questions?
I have one kind of cleanup question. This probably calls for an opinion or maybe outright speculation. I have often said that we can expect a certain result from the Supreme Court if the Supreme Court justices are honest brokers of the law. And the word "if" does a lot of heavy lifting in that sentence because it feels like now more than ever, politics has really crept into the Supreme Court. Are you confident that you're going to get an opinion out of the Supreme Court based on the law, based on the facts, that, is divorced not only from politics, but from the consideration that I think we all have, at least in the back of our minds, as to how the public might react to this, because it might inspire lots of very strong feelings depending on which way they rule, really regardless of which way they rule. How comfortable and confident are you that you're going to get a decision, a ruling that is based, primarily, if not exclusively, on the law, the facts, and the record that you all were able to create in the courts of Colorado?
Sure. Well, so one of my favorite lines from any justice ever was actually from Justice Scalia, who said, being a good judge means that sometimes you're going to make decisions that you really don't like. And I think that these justices are kind of in that situation. They might be in that situation right now where they say, okay, well, we have to make a decision here. And, we know that there's all these external pressures and, all these issues around them. And so given that, the easiest thing for them to do is simply fall back on the law and just say, look, we're going to put blinders on for all this. This is what the law says. This is what it reads. And we're issuing this decision. And that, I think, is the thing that will resonate best with America and across the country, is if they can say, well, they've said this is what the law is, and they've explained it, and they've explained it in detail. And the best way to do that, I think, is to apply the text, apply the history. And in that case, I think they come out on our side. I do have faith in these members of this court that they will move forward and proceed in a way that is governed by the rule of law. They've dedicated their entire careers to that. They are some of the most preeminent legal minds in our country. And I think that if they do that, I have faith that we will get a decision that all Americans can accept.
Mario, let's finish off with this. What's the timeline of what we can expect to see now? Obviously, tomorrow is the oral arguments on February 8th. So can you walk us through what we can expect now, starting with tomorrow?
Sure. So tomorrow, one member of our team, Jason Murray, will be making the oral argument. I will tell you all in your audience to tune in. He's a rock star. He's going to be incredible. He was a clerk for both Kagan and for Gorsuch. And he is a fantastic advocate. So I would say tune in for that. After that, there's nothing that dictates when the Supreme Court has to make a decision on the timing for it. But they understand that we're moving forward very fast, and they moved this case very fast. The fact that we're having oral argument on February 8th, just less than a month after, just over a month since cert was even requested, is lightning fast. They understand that our primary is on March 5th. Furthermore, it's Super Tuesday, so lots of states are having their primaries on March 5th. And I think that they will try to make sure they have a decision in advance of that. Whether that's 2 weeks from now or 3 weeks from now, I think they will make sure that they issue it so that people know whether the candidate they're voting for is qualified or not. And as I've said for other people, I do hope anyone who is considering voting for him in the primaries, if they do have a mail vote, holds that ballot until they find out whether he's qualified or not. Because I would hate for people to be disenfranchised because they voted for a guy who turns out he was disqualified.
Yeah.
So I think we'll have a decision by then. If we don't have a decision by then, I can't see the court wanting to push it back past that.
Okay. Well, with that said, thank you for, the work that you've done to protect the Constitution here, and best of luck to you and your team as this process continues to move forward. With that said, for those watching, Glenn and I will, of course, continue to stay on top of this case as it progresses. With that said, I'm Brian Tyler Cohen.
Glenn Kirshner.
You're watching The Legal Breakdown.